I'm Drew Stevenson, and this is a lecture for my administrative law class about agency subpoenas and record requirements or record keeping requirements. This is supposed to be a quick overview of the topic of subpoenas. My casebook actually doesn't include in the latest edition any primary cases for students to read, but there's a lengthy kind of note discussion. Other administrative law casebooks include some cases. I'm going to give you just what you really need to know about this. So first, most of the information agencies need or obtain is actually provided voluntarily, or at least sort of voluntarily, at least without objection, although usually agencies require it. And what do we mean? The regulated industry will typically have some record keeping and filing requirements, or is required to file annual reports or quarterly reports, and they just do it because it's the rule. And so the agencies get most of their information because it's sent to them without objection. But sometimes they actually have to force it. And there's three ways they do that. They have a subpoena power. So they can go get a subpoena and make you turn over the records. They have power to actually require maintenance and records and submission of reports. And so if you say, well, we don't keep those records at my business, they can say, well, now you have to. And they also can conduct physical inspections of premises to get the information that they need. We have a few old cases that are still in some administrative law casebooks, Endicott Johnson and the Oklahoma Press Publishing cases from way back in the New Deal era. And they suggest really three limitations on agency subpoena power. So this is what you really need to know about subpoena powers for administrative agencies. Subpoena power, one, must be explicitly authorized in the agency statute. It usually is, to be honest, that the agency will have the power to issue statutes, to issue subpoenas, but that needs to be specified in the enabling statute. Secondly, the information requested must be relevant to a proper subject of agency inquiry. And third, demand for the information must not be unreasonable. Now, for the second one, I want you to imagine, let's say that the Environmental Protection Agency is requesting information about the arrest records of all of your employees, or the racial makeup of your workforce, or how many men and women you have in management positions. Well, that's not the EPA's job. There's other agencies that enforce civil rights and anti-discrimination laws. Or imagine that OSHA, the agency that's supposed to monitor workplace safety and make regulations about workplace safety, is asking for information about your products and how they're affecting consumers. Well, how you're affecting consumers doesn't really have that much to do with OSHA. So the information, when they send you a subpoena, has to kind of fit within what that agency's mandate is from Congress. And again, they can't just say, please give us all the information your company has about anything. They have to be specific, and it can't be too unreasonable. So again, as I said, the information requested must be relevant to a proper subject of agency inquiry. Now, keep in mind that the party, I want to qualify number 2 from the last slide, the party subject to the subpoena does not have to be under the agency's authority. So for example, there's an old case in the notes in my casebook where the US Department of Agriculture subpoenaed bank account records for suspected regulatory violator. They were trying to trace the money trail for somebody who was violating USDA regs. So a lot of times subpoenas are actually served on banks, even though the agency, like the USDA, they regulate farms, not banks. But so the party that gets the subpoena is not necessarily under the agency's jurisdiction. Instead, it's the target of the investigation who's supposed to be. Just make sure you keep that straight in your mind. Now, please, when we talk about the statutory authorization in the enabling statute, it's usually going to be general, and that's okay. It does not have to mention what type of information agencies can subpoena, it will usually just say the power to issue subpoenas. Now, keep in mind that it can't be too unreasonably burdensome. So they can't use this to harass you by asking you for every email that a large corporation has ever generated or something like that. They can't be too general. They need to be sort of specific, but they can still be burdensome, just not unreasonably burdensome. And of course, this is somewhat going to be in the eye of the beholder for the court when this is contested. Also, keep in mind that agencies don't have to tell the target of their investigation that they're subpoenaing records about them from banks and so forth. So if the IRS has you under investigation or the FBI, they don't have to tell you that they're trying to get your bank records or phone records or things like that. They can just do it. Now, maybe your bank is going to call you and say, by the way, we just got a subpoena from the FBI for your bank records and give you a heads up, but they don't have to. And the agency doesn't have to tell you that they are investigating you. Now, the Supreme Court has held in several cases that agencies like the IRS can subpoena records for the purposes of helping criminal enforcement proceedings. And courts now may require sometimes an agency to explain the reason it needs for the information. If it's a little weird what the agency is asking for, it is legitimate to challenge the subpoena, and then the agency is going to have to tell the court why they think they need this information. Now, what about asserting Fifth Amendment privileges in response to an agency subpoena? Well, first of all, I have a few points to keep in mind. The Fifth Amendment privilege against self-incrimination applies only to liability for criminal prosecution, not to potential civil liability or loss of a job. So the fact that you might get fired if the agency finds out this information, let's say because you've been incompetent or missed some deadlines or something like that, or you could get sued or subjected even to civil fines from the agency, you're not going to be able to invoke your privilege. It would only be if you could face actually imprisonment or criminal charges. Also, there's a question about whether the Fifth Amendment privilege against self-incrimination really applies to corporations. And we have cases about this that I don't want to spend too much time on here, but that is a question about whether the privilege, to what extent it applies to corporations or just natural persons, actual human beings. But definitely keep in mind that the custodians of a corporation's records can't refuse to disclose them just on the grounds that they would incriminate the employees themselves, right? So it's a corporation's records. And the fact that if you turn over your corporation's records, then somebody's going to find out that you've been embezzling money. The privilege, you don't get to invoke the privilege because it's somebody else's information. So the records are the corporations, not the employees. Also, keep in mind, you can't invoke the Fifth Amendment privilege to save someone else. You can't refuse to disclose it because it might incriminate others, even your best friend or your boss or your favorite secretary or something like that. The privilege is personal. You can't really claim the Fifth Amendment on behalf of others. Statutory grants of immunity can also make Fifth Amendment privilege moot in an individual case. And so what happens is you try invoking at trial or pre-trial, usually discovery, trying invoking the Fifth Amendment right against self-incrimination, say, I don't want to disclose that or answer that question. And if the state says, or the government's lawyers say, we'll actually grant immunity for whatever they're about to say, like we can commit here on the record that we won't use this statement as the basis for a prosecution, we just need the answer, well, then it's not going to be incriminating because you've been given basically temporary immunity for that statement. And that is then you're going to have to answer the question or make the disclosure. Now, please note that attorney-client privilege is more likely to work than invoking your Fifth Amendment privilege in response to a regulatory subpoena. And so sometimes if your lawyer has the document and the document was really a communication between you and and the client, the lawyer and the client, that could be covered by attorney-client privilege. On the other hand, what doesn't work is just turning all of your corporation's documents, like everything, just over to your attorney all the time. That you can't apply privilege to pre-existing documents. Now, here's a final word that's kind of an obscure point, but something you should keep in mind for when you're in practice as a lawyer. Most agencies normally have to convince the Department of Justice to enforce these subpoenas if they're resisted, if people ignore the subpoena. And that means you have to get a DOJ lawyer to champion your subpoena when you're at another agency. And you're going to find, if you work for a government agency, that the Department of Justice, these U.S. attorneys, want to weigh a whole bunch of priorities, so administrative and law enforcement and budgetary considerations that are rarely discussed in some of the other agencies. So these are busy lawyers who are used to triaging and prioritizing cases when they go to court. And a lot of times the people at the agency who want a subpoena aren't used to thinking like that. And by the way, this can create tension sometimes between the agencies and the DOJ over these under enforced subpoenas. And sometimes agencies give up on issuing them. Okay, let's talk briefly about record keeping requirements. So this is where we pass a regulation saying all these businesses have to start keeping certain records. And these can raise similar issues to the subpoena power, but we're going to answer it the same way with the agency's statutory authority, the relevance to the agency's legal objectives, and the reasonableness of the record keeping requirement. We have an old case from 1950 that's in a lot of administrative law casebooks, US v. Morton Salt Company, where the US Supreme Court upheld agency authority to compel record keeping and submission, although in that case it was part of a consent decree settling an antitrust case. The Supreme Court has generally endorsed demands for record keeping or requirements as long as they meet the three tests. Again, that it's authorized under the agency's enabling statute, at least generally, and it's within the agency's sort of legal bailiwick or under its statutory purview, and that the requests are basically reasonable, even though they could still be burdensome. And the main difference from subpoena power is that here the agency orders the assembly and retention of information, even if you don't have to turn it over. They could just say, you have to keep all these records in case we ever need them. And this is actually pretty common. And so it's not a disclosure record requirement. That's why we distinguish it and talk about it as a distinct legal requirement. Okay, that concludes my quick overview about subpoena power and record keeping requirements for regulatory agencies.